Hi, everyone, and good evening. I am immigration attorney Yael Brudner, live here from Southern California, answering your immigration questions today. I have some questions that people sent over this week, and I would love to answer them here live. But if you have any other questions that you want me to answer live, feel free to write them in the comments, and I will get to them as soon as possible. I am streaming to TikTok, Instagram, and Facebook and YouTube, so sometimes the questions go pretty quick. If I miss your questions, I apologize in advance. Just write your question again or just send me a direct message. So, immigration questions. We get questions all the time sent to us either on our website, Facebook page, Instagram, direct messages. And I picked the top questions that I thought would be interesting for a lot of people. So let's see. This question we received, it says, my boyfriend is a green card holder. Can he petition me for a fiance visa? We get this question a lot. It's really common. Unfortunately, you have to be a US citizen to petition your fiance for a fiance visa. Okay, so your boyfriend will first, if you want to go the route of fiance visa, I would ask you how far your boyfriend is from naturalizing, from becoming a US citizen. Or perhaps you should consider filing a spousal visa or a marriage case petition after you guys get married. As a green card holder, he can petition his wife. He just can't petition his fiance. So unfortunately, green card holders can't petition for a fiance visa, but they can absolutely petition their spouse for a green card, which is better than a fiance visa, right? So I hope that answered that question. Feel free to contact us. And if you want us to talk specifically about your case, happy to talk more in detail. Let's see. Thank you for everyone that's joining. I do see some questions, so let's see if I can answer some. So Rahul is asking, hi, madam, I have a VD, which is voluntary departure, but haven't left and have a USCIS cases pending. How can I fix the situation? Okay, so that is definitely a more complicated situation. Not something I can answer really quickly over social media, but please contact our office, schedule a consultation with me, and we can discuss your case more in detail, okay? Anytime there's a deportation order or you are already in immigration proceedings, it really does require a one-on-one consultation. Okay, Javier is asking, why do they only have 3 immigration judges to process tens of thousands of cases? That's a great question. It's a huge problem. The immigration system here in the US is completely backlogged. There's not enough judges. There's not enough, dates on the calendars for immigration cases. And a lot of cases are taking a long time because of that. But part of the immigration reform that the Biden administration is suggesting is to really revamp the immigration system and to improve it and to increase numbers and quotas and just to streamline the process more. So hopefully we'll see some improvement if that passes. Okay, so thank you for your question. Okay, Robert, I do see your question. Please contact me. It does require a more one-on-one personal consultation. Okay. Angela is asking, can anyone get legal status after being deported? That's a great question. And the answer is that yes, you might be able to get legal status even after you got deported. So very, very case specific. Situation specific. Definitely reach out to us to evaluate if you qualify for one of the exceptions, and we'll be able to get status after you're deported. Okay, so if someone was ordered deported by a judge or at the border, then they should, deport the U.S. and they need to spend a specific amount of time outside of the U.S. If they didn't deport or they didn't spend enough time, there's certain situations where they might qualify for an exception. Okay, this could be a U visa, a T visa, maybe a VAWA application. Okay, perhaps you can request a special permission to return before the time is done if you're outside of the U.S. So definitely call us. Okay, our number is here on the bottom, or you can reach out through me through our website. You can find my link in my bio. Okay. Okay. Thank you guys for all your questions. I love it. Please feel free if you have more questions to reach out right here in the comments, and I'll love to answer your question if I can. Another common question we get, I'm just going to put it up here, is for people that are green card holders and they want to apply for citizenship to become U.S. citizens, but they have a criminal record and they don't know if they can apply for citizenship or not. So this is a question we get often. I've been a green card holder for more than 5 years, but I have a criminal record. Can I apply for citizenship? The really annoying answer is that it depends. So it depends what your conviction was for, like what you were convicted of, and when did this conviction take place. Okay, there are certain crimes or convictions that are a complete bar to citizenship. So really serious convictions, aggravated felony convictions. If you were convicted of an aggravated felony, you're not going to become a U.S. citizen. It's a complete bar to applying for naturalization. Other convictions that are less serious. They would be evaluated on a case by case and specifically to see when they occurred. If you apply for citizenship, the general application 5 years after becoming a U.S. citizen, they want to see that you're a person of good moral character within the last 5 years. So if you were convicted of a crime and it was in the last 5 years, I wouldn't recommend filing for citizenship. If it was before that, we would definitely evaluate and see the conviction and advise you if you should apply or not for citizenship. There's a lot of discretion that goes into citizenship applications. So the officers that deciding the case have a lot of power to decide if they want to approve it or not. Okay, so if you have a conviction on your record and you're thinking of applying for citizenship, it's worth consulting with an immigration attorney that will review your record and advise you if you should file or not. And it's really important because it's actually a little bit risky to file for naturalization if you have a conviction on your record, because some convictions could cause you to become deportable from the US. So if you're a green card holder and you commit certain crimes, you might be deportable. So you don't want to expose yourself. You don't want to file something affirmatively with immigration when you can possibly become deportable due to that crime. So anytime there's a criminal record and you're filing anything with immigration, make sure to consult with an immigration attorney. Okay. And if you want to consult with me, I'd love to talk to you. You can feel free to reach out to me anytime to schedule a consultation. Okay, let's see. Robert on TikTok is asking, or on Instagram, sorry, is asking, what are crimes of moral turpitude? That's a really good question. Crimes of moral turpitude, or we call them in short CIMTs, are crimes that are considered especially serious or especially ones that are morally impactful. Okay, so crimes that involve theft, that involve lying, fraud, domestic violence, or things like that. Certain crimes could be categorized as crimes that involve moral turpitude. Those crimes, if you're convicted of one of those, are specifically bad for immigration, let's say. Okay. it's really problematic if you are convicted of a CIMT and you're applying for an immigration benefit. It's not that it's not possible to still get an immigration benefit, but it gets a little tricky. So definitely, talk to an immigration attorney if you think you're convicted of a crime that is classified as involving moral turpitude. Okay, and there's no list of what crimes are yes or no. It's based on case law and opinions by judges that concluded that a certain crime is a CIMT. Okay, great. Let me just see if I'm seeing any more questions. Okay, any updates on DACA? Good question. So DACA right now is available. It's open. You can apply for DACA. Initial applications are accepted. Advanced parole applications are accepted if you already have DACA. So definitely, if it's something that you're thinking about, apply for DACA. If you're asking about options for people that already have DACA, there's nothing that has passed right now and become law, but there are. It is in the works. Okay, there is a lot of hope that finally DACA dreamers will be able to have a path to citizenship. It needs to pass the Senate. It still has a lot to go, but it definitely looks more promising that it has ever looked. Okay. Let's see. Well, thank you for everyone that's joining. If you're joining right now, I am attorney Yael Brudner. I'm an immigration attorney, and I'm answering immigration questions today. So if you have any questions, feel free to write them in the comments. Javier is asking, what if your case got dismissed? So for immigration purposes, a conviction is still a conviction, even if your case got dismissed by the court. The only exception is if your case was a juvenile case, so it happened when you were under 18 and you were tried in juvenile court, or if your case was vacated, so it was dismissed based on a reason why you should not have been convicted in the first place. So if it was just dismissed because time has passed and you are able to expunge the conviction, that unfortunately is not enough for immigration. Okay. Yassine is asking, how can I get U.S. citizenship? I'm a high school student. Awesome. Well, thank you for your question, Yassine. You have to first become a green card holder. So I don't know what your current status is right now. If you are a green card holder, so a lawful permanent resident in the U.S. for more than 5 years, then you can get then you can apply for citizenship. Now, you say you're in high school, so you're probably under the age of 18. I would want to ask you what your parents' status is, where you are, where you live. A lot to ask. Okay. Yeah, you have a green card. Cool. So you have to have a green card for 5 years and be at least 18 to file for naturalization. But what are your parents' status? Okay. Okay, let's see. There's a question here. I have DACA. I'm married to a U.S. citizen, and I have a son. Do I still need to go to my country after I file? So that's a good question. And the answer is that it depends on when you received your DACA. If you received DACA before age 18, and you've been on DACA ever since, that means that you didn't accrue any unlawful presence here in the U.S., and you won't need to leave the U.S. in order to get your green card. Okay, most likely. You won't need you won't need a waiver. Unfortunately, most likely, if you did enter without authorization, then you would need to leave the U.S. in order to complete the process. Okay, sorry, I confused it for a little bit. So I'll answer it again. If you have DACA and you're married to a US citizen, you most likely will need to leave the US in order to complete the process of the green card, because you didn't enter the US legally. However, if you receive DACA before the age of 18, you won't need a waiver because you didn't accrue any unlawful presence. Okay, it gets a little tricky. Definitely contact me so we can talk specifically about your case, okay? Let's see. Okay, just checking to see questions like on all different places where I'm streaming. Okay. Okay. So Sugar is asking, what if I have a family member that's sick and I need to travel now? So if you're on DACA and you have an immediate reason why you need to leave, you can apply for something called advanced parole. With the advanced parole, that will give you an option to travel to visit your sick relative. Now, if you get advanced parole and you travel and you come back, okay, then you can apply for your green card in the US, because then you have a legal entry, okay? It's really recommended to try to apply for the advanced parole for the special travel document, because that would allow you to get a legal entry, which is super important for adjustment of status. You have to have that in order to file for your green card in the US in the majority of cases. So they don't give the advanced parole to everyone. You need to show that you have a real reason why you need to travel. So if you have a sick family member, you have to show evidence that you have a sick family member. So doctor letters, affidavit, letter from your sick family member or other family members, and just to show proof of that. Okay. Well, advanced parole is pretty safe. I see you're saying, is there any way I'll be held and not be able to travel or re-enter? This is something that, generally speaking, advanced parole is pretty safe, but I would want to review your case and make sure that there's no other reasons why they would not let you come in. Other reasons could be if you have a criminal history or anything like that would make you inadmissible. So if you're considering that route, definitely talk to a lawyer, and I'll love to help you. Okay. Let's see. There's a question here. BB's asking, I came at the age of 17. I have 3 kids, never left the US. Can I apply for a new DACA? So came at the age of 17. You had to have come at 16 or younger. Okay. Are you married to a US citizen or to a green card holder? That could be an option. Call us and see if there's anything we could do to help you, okay? Let's see. There's a question. Can a child support order affect a pending case? What case? A green card case? Give me more information. Okay. Let's see. You're not married to a US citizen. Okay. But definitely reach out to us and we can do a full immigration evaluation and see if there's any other options for you. Okay. Yeah, Sugar, do you have no criminal record? That's really good. I would try to apply for the advanced parole. It takes a few months to get, but definitely try to do that. Because if you do get advanced parole and you travel and you come back, that will help you get your green card here in the US. Okay, guys, let's see. There's a question here on Facebook. I'm a US citizen. Can I petition my cousin for a green card? Unfortunately, you cannot petition your cousin. US citizens can petition their parents, their spouses, their children, and their siblings, but cousins, unfortunately, are not one of the categories. If you're a US citizen, you can petition your sibling, your brother or your sister, which can then petition for their kids. But that is a long process. I know it's frustrating, but cousins are not one of the categories. Okay. Another question I have here on Facebook. I'm a U.S. citizen that lives abroad with my spouse. Can I petition her for a green card from abroad? Okay. So a U.S. citizen can live anywhere they want in the world. Okay. Many U.S. citizens travel and they meet people and they fall in love and they get married in a different country. Even if you're in a different country, you can still apply for your spouse for a green card. Okay. It's still available. It's still an option. Your spouse can then do what's called consular processing. So apply for an immigrant visa at the U.S. consulate or embassy at her home country, and then enter the U.S. and become a lawful permanent resident. There's one little thing that you need to think about is that in order to petition someone, you do need to show that you have an intent to reestablish your life in the US. So there's a little step you need to do in addition to the regular steps if you are living abroad. But if you do plan to return to the US with your spouse once he or she gets a green card, then you can absolutely do that. And I would love to help you. If you need help in your process, please feel free to contact us and get that going. Okay, guys, I'm going to wrap up the questions for today. If you have any questions, you want to talk to me further, please call or text me, schedule a consultation at my office, and I would love to talk to you further about your case. So in the meantime, thank you for everyone that joined and for everyone that asked questions. And I promise to come back live really soon.